We're going to hear from Michael Connolly and Avi Sharabi, and they will discuss the recent, not that recent, but still current and currently being applied and mulled over case of Marcum and AIG. This case, as many of you know, dealt with concurrent liabilities of insurers where they were hold harmless contracts between co-defendants. And this scenario comes up all the time, and in my experience it's dealt with slightly differently each time, but you're going to hear about some of the general principles that we can glean from this case. So we'll start with Michael Connolly.
Okay, thank you, Frank. And thank you for everyone sticking around for the final presentation today. As Frank mentioned, my name is Michael Connolly, and along with my co-presenter, Avi Sharabi, we're pleased to present our paper entitled Double Duty, the Equities of Concurrent Duties to Defend. So just to set out the framework for this presentation today, I'll be introducing some of the facts that underlie the Marcum versus AIG decision. And then I'll be passing that on to Avi, who will put the court's findings into context and discuss how they move the law forward. So, as the title suggests, our papers are about concurrent duties to defend. What are they and when do they arise? Generally, concurrent duties to defend describe situations in which multiple insurers owe a duty to defend to one or more insureds for different kinds of claims, and applies in instances where both of those claims are alleged in an underlying action. So concurrent duties arise, they may arise where one loss triggers multiple insurance policies that cover the same insureds, or where one loss triggers one policy that covers two insureds. Practically speaking, concurrent duties to defend arise where both insureds enter into some sort of joint venture, and that might be a commercial agreement, a tenancy agreement, or a rental agreement, or a service contract. As Frank alluded to, it's not uncommon that many of these underlying agreements have hold harmless clauses for the benefit of one of the contractual parties. So what we mean by that is where one contractual party promises to defend and indemnify another contractual party in the event that any claim is brought against them as it relates to the nature of that underlying agreement. As well, it's common that these underlying agreements state that one contractual party is responsible for retaining insurance for the benefit of the other contractual party, who they must name as an additional insured under that policy. But the issue that arises for insurers in some cases is where both contractual parties are named as co-defendants in the same action. And so sometimes the insurance policies or the contracts dictate who must defend and indemnify whom in such cases. Where the underlying agreement is insufficient and doesn't adequately address the situation, it's not uncommon that those parties must move before the court for direction. And that's sort of the crux of the Marcum and AIG decision. And so this is a recent decision of the Court of Appeal from 2019, and it serves as an excellent case study because it's the opportunity for the court to address many practical issues that arise for insurers in the event of concurrent duties to defend. And that's because of the unique nature of the facts. So the coverage issues arise from underlying personal injury litigation in which the plaintiff is a spectator at a hockey practice who is struck when a stray puck leaves the rink and strikes them. Now, in that underlying action, the plaintiff names three defendants. First, they name the city of Marcum, who is the owner of the rink. Second, they name Hockey Canada, who is the organization that's responsible for having organized the hockey practice, as well as the Marcum Waxers, who are the OHL affiliate, and they also played a role in organizing the hockey practice. Each of those defendants has their own insurance policy. So Marcum is insured under a standard CGL policy issued by Lloyd's. As well, Hockey Canada is insured under a standard CGL policy issued by AIG. But pursuant to the rental agreement between Markham and Hockey Canada, Markham is added as an additional insured under the AIG policy. Now, while we don't have the statement of claim, so we don't know the exact wording of the allegations against all the defendants, we know that there are mixed allegations. And what I mean by mixed allegations are allegations that are covered under one insurance policy and perhaps not covered under the other. So when we talk about this case, we're primarily talking about two kinds of claims and allegations. The first we're going to refer to as game claims. These refer to the allegations raised by the plaintiff regarding the actual organization and facilitation of the hockey practice that day. These are, on its face, relate to Hockey Canada and Markham as it relates to organizing the game, and would be contemplated under that rental agreement between those two parties. But the second kind of claim are what we're going to refer to as the rink claims. And these are claims raised by the plaintiff against the city, alleging that the city was negligent in how it designed the hockey rink so as to enable the personal injury to have occurred. So, given that we have two insurance policies, two kinds of claims, one kind of claim that may be covered under more than one policy, and one that would almost not be covered under one policy for sure, the issue then becomes, well, who's responsible for defending the city? So with any coverage application, the relevant analysis always begins with the language of the policy. So we put on bullet points here from the AIG policy. So you can see the actual precise wording and language. So the first bullet point basically is the indemnity provision, and it states that AIG agrees to indemnify the named insured for claims of bodily injury. The second bullet point is the duty to defend provision. In particular, the language is that AIG retains the right and duty to defend any action seeking damages for which that insurance applies. So the breadth of that language is important. It's for any action seeking damages for insurance that the AIG policy would cover. As well, we've included the endorsement, which adds Markham as an additional insured under the AIG policy. But it's important to note that Markham is only added under the AIG policy as it relates to the game claims. So again, only for the claims regarding the organization of the event. Similarly, we have the wording of the Lloyd's policy. And the first bullet point states that Lloyd's agrees to indemnify the named insured, Markham, for all sums for which Markham may be found liable, resulting from bodily injury. As well, just like AIG, Lloyd's retains the right and duty to defend, as well as the right to investigate, negotiate, and potentially settle claims as against Markham. Now, because we're dealing with two different insurance policies that overlap to a certain extent, it's important that we look at how the policies contemplate that sort of situation. And on its face, both insurance policies seem to address the issue. The AIG policy states that in the event of other insurance claims, it will act as the primary insurer. Somewhat complementary to that, the Lloyd's policy states that in the event of other insurance, it will act as an excess insurer. So again, on its face, this seems to answer the question about some of the claims. But what about those rink claims for which no coverage would be afforded to the city by AIG? And that's what really the issue that gives rise to the coverage applications brought before the court. So in this case, both the City of Markham and AIG bring coverage applications. In its coverage application, Markham alleges that AIG must defend the city for all claims, including the rink claims, pursuant to the endorsement adding it as an additional insured. But they also say that there's a conflict of interest between the City of Markham and AIG in the sense that should AIG be responsible for instructing and retaining defense counsel, it does have an interest in trying to allocate any liability against the city of Markham and attribute it to the RINC claims so that no indemnity would be provided under the AIG policy. So on that basis, the city of Markham takes the position that there is a conflict of interest that enables it the exclusive right to instruct and defend, or to instruct and appoint defense counsel. Now, in AIG's coverage application, it concedes that it owes a duty to defend to the city of Markham. But it argues that the presence of the RINC claims requires that Lloyd's be found to also owe a concurrent duty to defend, and they must contribute to that defense in some way. Further, AIG, referring back to the right to defend provision in the policy, states that it retains the right to defend and has a right to participate in the defense of the city, and that there is no conflict of interest that would void that right. So it may be useful to just go over some of the basics of the law leading up to the Markham and AIG decision. So the duty to defend is an obligation that arises from the policy. And accompanying the duty to defend is the insurer's right to instruct counsel, to investigate claims, to negotiate, and to potentially resolve claims early on. Now, while the duty to defend is an obligation arising from the policy, it's triggered by the actual pleadings of the claim against the insured. So the common law test by which courts measure whether or not a duty to defend is owed is whether there exists a mere possibility that the insurer would indemnify the loss should the allegations in the pleadings be found to be true. Generally, case law suggests that the courts will look to the true nature and substance of the claim when finding whether or not a duty to defend is owed. So in this sense, simply because a cause of action is pleaded for which the insurance policy would provide indemnity, simply just because that's pleaded doesn't mean a duty to defend will be owed where the actual facts do not support that cause of action. Now, all of this analysis becomes complicated when insurers have to deal with statements of claim that include covered and uncovered claims. Insureds also, there are further considerations for insureds where co-defendants who are named as additional insureds under the policy are also named as co-defendants in the underlying action. Now, some of these issues were addressed by the 2015 Ontario Court of Appeal decision of Carnero versus Durham Region, and many of you may be familiar with this case already. The coverage issues arise from underlying motor vehicle accident litigation in which a driver is killed as a result of winter weather conditions on the road. Now, the plaintiffs in that underlying action are the family members of the driver, and they bring an action against the Region of Durham, alleging that they were negligent in how they designed the road. And they also bring a claim against Miller, who is the service contractor and road maintenance crew hired by the Region of Durham to plow and ice the roads. And they allege that Miller was negligent for failing to maintain the roads. So in that case, there's a contract between Durham and Miller. And that contract contains a hold harmless clause to the benefit of Durham, in which Miller agrees to defend and indemnify Durham for any action arising from the road maintenance contract. As well, Durham is added as an additional insured through Miller's policy, which is issued by Zurich. So Durham seeks a defense from Zurich. And Zurich initially denies owing a duty to defend on the basis that the allegations against the city are for negligent design, which fall outside of the scope of the service contract with Miller. And therefore, there would be no indemnity under the Zurich policy, and therefore no duty to defend. Now, this case goes to the Ontario Court of Appeal, and the court there finds that, well, Zurich does owe a duty to defend Durham. By looking at the Zurich policy itself, they state that the Zurich policy contained an unqualified duty to defend. So they consider the language of the Zurich policy, which states that it covers claims of personal injury that are, quote, caused in whole or in part by Miller's acts or omissions. So this is unqualified in the sense that the duty to defend provision didn't simply say that it would defend claims for which coverage would be owed, but for all claims that are caused in whole or in part by Miller's acts or omissions. So the court's order in that case is that Zurich is responsible for paying defense costs incurred by Durham to defend the covered claims, even if that defense also advances the defense of uncovered claims. However, Zurich is not responsible for paying those defense costs incurred solely to defend uncovered claims. So while Zurich, in that case, retains the right to seek reallocation upon disposition of the underlying action there, from a practical standpoint, it's not always easy to bifurcate between defense costs incurred to defend covered claims from those solely incurred to defend uncovered claims. So, insurers in similar positions as Zurich here may be in a situation where they have to fund all defense costs. And so a distinction can be drawn right out of the gate between Carnero and Markham, in the sense that Carnero is not a dispute between two insurers about which one of them owes a duty to defend in the instance of that claim. And so the analysis of Carnero, I would think, may have been different had Zurich brought in Durham's other insurer. And so Avi will touch on that a little bit later. But why we bring up Carnero now is because it's an important decision that's relied upon by the application judge. So relying on it, she finds that, similar to Zurich and Carnero, AIG provided an unqualified duty to defend. So you'll recall that the language in the AIG policy is that it will defend any action seeking damages for which coverage is found under the policy. So relying on Carnero, the application judge extends that to say that, well, in this case, AIG owes the city a duty to defend even the uncovered claims because the language didn't specify. Now, interestingly, she extends the Carnero analysis to find that, well, given that AIG has this unqualified duty to defend, it doesn't make economic sense for Lloyd's to also owe a duty to defend because it logistically or economically wouldn't make sense to have two insurers instruct two different lawyers to defend two different kinds of claims against the city in this action. So right up front, this is problematic because the economic sense analysis is not the correct analysis for basing a duty to defend. As well, the application judge agrees with the city of Markham and finds that there is a conflict of interest between AIG and the city, so that the city is permitted to independently instruct defense counsel, and AIG must then pay the defense. So AIG appeals, and this proves to be an excellent opportunity for the Ontario Court of Appeal to address and explore three main issues that commonly arise when dealing with concurrent duties to defend. The first issue is, well, what is a concurrent duty to defend? What is the law around it? And how are these sorts of types of disputes to be adjudicated? Secondly, the court addresses how are defense costs to be allocated in cases of concurrent duties to defend? And third, the court addressed the right to appoint and instruct counsel. How do concurrent duties to defend relate and intersect with the rights of the insurer to instruct and defend counsel and the rights of the insured who is entitled to a fair and full defense? And what kind of facts give rise to conflicts of interest that would vitiate the insurer's right in that case? So unless there's any questions, I'd like to pass this on to Avi to discuss the court's findings.
No, we don't have any questions, or if we did have a couple, I will leave them to see if we have time at the end. Avi will now talk about the Court of Appeal decision in the Markham and AIG case and some of the considerations that flow from that.
Thanks, Michael, for setting the table on that issue. As Michael said, I'm going to do a deeper dive into the results of the three issues on appeal and how they affect the case law going forward. So I'm going to jump right into issue one, which was the duty to defend issue. And briefly, the court found that AIG owed the city a duty to defend, Lloyd's owed the city a duty to defend. Now, these concurrent duties, you'll see from the course of my part of the presentation, I'm going to call them complementary duties to defend, and I'm going to tell you more about what I mean. First, I want to sort of go over some of the general principles that I view that you can take from Carnero, from the Markham and AIG case, and from decisions that have flowed since Carnero and going forward. As Michael spoke earlier, he's talked about the unqualified, or the concept of an unqualified duty to defend. And I think that sort of maybe confused the issue the way that was put by the Court of Appeal a few years ago. Because, of course, insurer says, what do you mean unqualified? There's always qualifications in our policy with respect to exclusions and so on and so forth. And what the Court of Appeal essentially said was, we mean unqualified in the sense of when you deal with mixed claims, as Hannes and Teven, that the older Court of Appeal decision tells you, if there's a situation where you have mixed claims, you're going to have to be on the hook, if you're the sole insurer, to defend everything and then reallocate later. And so what I'm going to suggest to you is the concept of an unqualified duty to defend doesn't automatically require a single insurer to assume complete responsibility for defending mixed claims, and the caveat being when there's another policy in play. And flowing from that, I want you to think about the concept of duty to defend with multiple insurers. So a duty to defend of one insurer isn't vitiated by the duty to defend of another insurer. You can have these types of scenarios. So what you always want to do is consider the nature of the policy wording of each policy with respect to that statement of claim. And I'm going to explain in more detail what I mean. So I spoke about complementary coverage, and I want to contrast that from what I'll call overlapping coverage by looking into exactly what the Court of Appeal ruled on the duty to defend issue. So as Michael was suggesting to you, there were two kinds of claims, the rink claims and the game claims. And so what the Court of Appeal essentially found was that everything to do with the game claims was captured under the AIG policy. And so the named insured, Hockey Canada, and the other named insured Waxers obviously fell under the game claims. The additional insured to the AIG policy was an additional insured arising out of the operations of the named insured. That fell under the game claims, so that was the city as well. Now, this was a scenario of what I'll call overlapping policies, and I'll get a little bit more into that when we talk about allocation. But suffice to say, when you have overlapping policies, you're looking to the other insurance clauses of each policy, because you essentially have the exact same policy or the exact same coverage, and I'll explain more on that soon. And so what the Court of Appeal said was, well, when you have one policy saying it's primary and the other policy saying it's excess, as in this scenario, AIG, the primary insurer, is going to cover the city, but Lloyd's is not going to have to be engaged at this point for the game claims. However, the Court of Appeal then says that doesn't really apply. The whole other insurance analysis doesn't apply to the rink claims, because the part of the claim that's the rink claims of what we're calling doesn't engage the AIG policy. It only engages the Lloyd's policy. So you in effect have two concurrent primary duties, which is what I'll call complementary coverages. Both are primary for the same insurer within the same claim. The other insurance clauses don't interact. And now you have both policies essentially covering this claim. And so why do you bring this type of application if you're AIG? You do so essentially because you want to get allocation of defense costs. You're going to talk about indemnity later on, but in the meantime, you don't want that language from Carnero to come back and bite you, and you have, your unqualified duty to defend means all of a sudden you're defending claims that you really don't want to be covering. So that brings me to the second issue, which is allocation. And simply put, what the court said on allocation was AIG and Lloyd, since they both had duties to defend, they both had to contribute defense costs, and they do so on an even basis, 50-50 split. And I'm going to suggest to you that that's consistent with established case law. And I said before I'd talk a little bit about overlapping coverage, and I want to talk about it in the context of equitable contribution versus equity. So what I mean is this. When you look at, and I've listed Family and Lombard, it's a 2002 Supreme Court decision. When you look at a Family and Lombard scenario, as I'll call it, it's the scenario of overlapping coverage. It's what you have with AIG and the city with respect to, or AIG and Lloyd's with respect to the game claims. You have the exact same type of policy for the exact same insured, the exact same nature of coverage. And there's a whole 6-part test that the Court of Appeal talks about, the Supreme Court and Family and Lombard talks about. But essentially, when you have that test met, as you do with AIG and Lloyd's with respect to the game claim, then you look at the other insurance clauses and you say, okay, is one primary, is one excess, are they both excess, which is what happened in Family and Lombard, and so they both essentially drop down and become primary. What happens there? What the Court of Appeal in Markham and AIG do, and they don't refer specifically to equitable contribution, they allocate on an equitable basis. Because when you have two insurance policies covering the same insured, you don't have a contractual relationship between the insurers, but you do have an equitable right of contribution. You just don't call it equitable contribution necessarily. Is it a distinction without a difference? Probably. But I wanted to point it out because you don't always have to say, well, we don't have a perfect equitable contribution scenario, and that's okay. Because in this case, when you talk about the game claims versus the rent claims, you don't care about equitable contribution. You don't care about the other insurance clauses. What you do is you care about, looking at how you can split up the claim. Does one claim attach to one policy and does one claim attach to the other? And if so, you can have what I've been calling complementary coverage. And so, as I was suggesting to you, the Court of Appeal got it right in terms of how they allocate. Now, allocation of defense costs is generally done not in a very precise mathematical way. What ends up happening often is the insured gets to decide who they want covering them, but they don't get the final say. Because as the insurer, you can say, well, is there another policy in play that I should be seeking contribution from? And then ultimately, the insurers can work out how an allocation could be drawn up, or you can do so in court if the parties can't agree. As I said before, it's an equitable-based remedy, which essentially means fairness. And I don't want insurers, I think looking at this Markham and AIG case, I think it's very important for insurers not to gloss over the concept of the fact that an insurer is not obligated to pay costs solely related to uncovered claims, even if they have a duty to defend. Now, let's sort of put this all together, and I'll explain to you why I say the court got it right. Let's put this all together in the example of Carnero. So let's pretend that in Carnero, the municipality's insurer was involved in the application. Now, when you look at Carnero, there were two claims. There was a claim for negligent winter maintenance and a claim for design of the roadway. So there was a winter maintenance claim, a roadway claim. Just like in Markham and AIG, there was the game claim and the rink claim. So when you think about what could have been, in light of this case, I do think that there's a strong possibility that a court would have said, well, there's essentially complementary coverage here, and an allocation is warranted. Because even though there's an unqualified duty to defend the municipality by the winter maintenance contractor's insurer, that really arises out of the winter maintenance allegations. That insurer does not pertain, or that policy does not pertain to the design issues. And that's the named insured under that policy is the municipality in that case. So I do think you would have had an allocation. Now, how should it have gone? And what I meant earlier by I think the court got it right in terms of a 50-50 split, you have to think about how courts often come about, or how these scenarios come about in front of the courts. So sometimes you have a situation where you have multiple insurers defending the same insured because there's multiple policy periods involved. So then you usually do what's called a time on risk analysis, which is, let's say one insurer is on for 3 years and another insurer is on for 2 years, then you have sort of a 3-to-2 pro rata split between defense costs. Because remember, a court's not going to want to engage in a very complicated mathematical formula. When you have a primary and excess insurer and you're the rare case where you actually get contribution from your excess carrier, and if there's essentially 2 insurers for 1 insured, 50-50. Here, 2 insurers for 1 insured, 50-50. Now you could argue, if you go back and we want to try and relitigate the Carnero case, and you go back and you're the insurer for the municipality and you've just been told you have to defend too, maybe you want to look at the statement of claim and say, well, there was 1 allegation on the design of the roadway and 9 allegations on the winter maintenance issue. So really it should be a 90-10 split. But I think the counter argument to that is, should parties or should insurers sort of be bound by the way that a plaintiff writes their statement of claim? And I don't think that's the case, because when you look at the concept of a duty to defend, and first, some of the first principles that Michael talked about, you look at the nature and substance of the claim. Should it matter that there's 1 allegation or 10 sub-allegations? We all know how the negligence paragraphs go. They say, the defendants are negligent and these are the particulars, and then you list A, B, C, D, E, F, G. Should it matter that 9 of those are related to one and 2 of those are related to the other? I don't think so. There are 2 claims, there are 2 insurers, there's 1 insured, 50-50 allocation. So I think the Markham and AIG case gives you sort of an interesting perspective on how these claims have been handled as between insurers since Carnero, and how they can be handled going forward. And the last issue that the court talked about was the sort of pushback from the city in terms of its desire to have its own defense. And some insureds aren't very sophisticated. I found that municipalities are often quite sophisticated, and they want to maintain control of their own defense. And so in this case, that's what you had. What AIG proposed and what the Court of Appeal finally accepted with some substitutions was what I'll call a split file protocol. And what I want to note before I get into what it is that this was really the first major appellate endorsement of this type of protocol. We've had 1 or 2 cases at the lower courts that have sort of endorsed it, but never a real major Court of Appeal decision or major appellate decision. There's been limited discussion, and I think it provides a good sort of rule or guidance for insurers in terms of how to handle these decisions going forward. Now, the right to control your defense in a duty to defend policy, and I'm not going to talk about reimbursement policies because they're a bit different, but duty to defend policies, you have a right to control a defense, but it's not absolute. And it all comes from, the key case is Brockton and Frank Cowan, which is from the early 2000s. And you can see the test is very, very fact dependent. It's do the circumstances of the case create a reasonable apprehension of bias or conflict of interest. And whenever you see a test that says do the circumstances of the case, it's going to tell you that the court's going to have a lot of discretion in terms of how it's going to rule, which is why you have a myriad of decisions ruling on this issue. But as Michael was saying, the argument that was made by the city is not an uncommon argument. It's an argument that's often made by insureds when they want to control their defense, and it essentially is a liability argument. And so when you look at what the Court of Appeal did, it sort of addressed this liability argument head on and explained this is the nature of the conflict. AIG is obviously going to want liability attributed to the city so it doesn't have to pay indemnity. Lloyd's is going to want liability attributed to Hockey Canada, so it avoids indemnity, and the city doesn't want to pay its deductible, so it's going to want to push liability to Hockey Canada and the Waxers. But these types of liability tensions exist in every type of hold harmless scenario that we've been talking about. So, if a court's going to say, and they've said it in some instances, that these liability tensions are enough to sort of, vitiate your ability to maintain control over a defense, then I think that you're going to have situations where insurers are going to lose their ability to control defenses in every sort of additional insured scenario. And the court dealt with that, and they dealt with it by endorsing the split file protocol. Because what you have here is, a court essentially saying, and this is a major court of appeal decision, saying just because one party wants to push liability on the other doesn't necessarily mean there's a conflict of interest that's going to warrant taking away the insurer's right to control the defense. And this is a good way to handle this type of scenario. So what do I mean by split file protocol? First of all, you have multiple claims examiners. And we're going to focus on sort of AIG. So you're going to have a claims examiner dealing with the defense of the city. You're going to have a claims examiner dealing with the defense of its own named insureds, Hockey Canada and Waxers. And you're going to have a claims examiner dealing with coverage. The claims examiners are going to have, ethical firewalls in between their files. I'm assuming all your files are electronic at this point. There's going to be discipline for disclosure. Both insurers are going to equally instruct defense counsel. This protocol is going to be written down. Defense counsel for the city is going to report to everyone, AIG, the city, and Lloyd's concurrently. And obviously, defense counsel won't discuss any defense issues with coverage counsel. So as I was saying earlier, I think that this is a good way to handle a situation where you have pushback from an insured on its right, on the insurer's right to control the defense. Because what you have is a situation where the court's endorsed, and the court hasn't always done this, but the court's endorsed the insurer's ability to fairly and transparently defend the insured and sort of taken away some of that, cloud of bias hanging over this type of scenario. So in conclusion, I'd like insurers going forward to really think about, looking at the nature of the claim and the pleading versus not just their own policy, but versus the other policy. And don't just worry about overlapping coverage. Think about what I've called complementary coverage. Think about if you can really say, is there another type of claim that maybe our policy doesn't engage completely, and we don't even have to worry about the other insurance clauses? And remember that, you don't have, the nature of the good faith duty that you have isn't one way. It works both ways. The insured has to cooperate with you. The insured has to get you this information so that you can decide. The insured doesn't get to solely decide who covers them. You have a say-so as well. The insured should be working this out at the forefront. And finally, when you have these types of scenarios, I think it's good right at the outset to sort of put together a protocol that mandates fairness and transparency over above all, everything else. Let the insured know that there's not going to be a situation where, the claims examiner is going to maybe try to prefer one insured over the other. And I'm not suggesting that you would, but insureds often think so. And so when you don't have to do exactly what this split file protocol says, but if you have something similar where at least you split the file and you've let the insured know, and you have both insurers working out the defense in terms of who's the defense counsel, and everyone's getting the same, liability reports, I think you can, safely say, pointing to this case, that we've dealt with what we have to do to avoid bias. So thank you for, sticking around and listening to this presentation, and please let me know if you have any questions.
Yeah, Avi, there is one good question asked. It sort of came from revisiting Carnero and saying what would have happened in Carnero if there were two insurers involved, if the municipality insurer would have been part of that application process. The question is this: add another wrinkle to that. Both insurers are involved, and the municipality has a very high self-insured retention. Mm-hmm. So essentially, it's paying for its own defense. And it may be paying for the indemnity aspect of the claim as well. Would the court do anything differently given that wrinkle in the scenario?
Well, I think the court would still find the concurrent duties to defend. I think what it would mean, and I'd have to see what the policy wording said, but I think what it would mean is essentially the municipality's own insurer doesn't have to start paying those defense costs until the SIR, I'm assuming the SIR applies to defense costs, is exhausted. And you want to make sure when you're arguing that application that that's something that's argued and noted by the court, because you don't want to be in a scenario where all of a sudden your SIR is essentially abrogated and the court saying that the municipality's insurer has to start contributing right away. It has to be noted that, fine, if we have to contribute, we don't really start until the SIR is exhausted. So it does add a wrinkle, but I think it's something that can be dealt with that way.
Okay, there's a few questions, obviously, so I might go 1 or 2 minutes past the
Sure.
noon cutoff. The next question asks, do you think there would be any difference if the two policies involved were an E&O versus a CGL policy?
No, because, so I think you could argue that there may be a difference, and again, I have to look at the policies, but you could argue that there may be a difference if you're talking about equitable contribution. But if you're not talking about equitable contribution and you're talking about just equity, which doesn't involve the sort of, equitable contribution, you could think of it as sort of a specific type of equity. But as I said earlier, complementary coverage is just sort of about fairness. When you have two different insurers having duties to defend, it doesn't matter that they don't strictly overlap. One is a CGL, one is an E&O policy. If one responds to one aspect of the claim for the same insured and the other responds to the other aspect of the claim for the same insured, then you have two concurrent or complementary duties to defend. They're both primary, and I'm assuming, and there should be an allocation.
There are other questions, and I apologize to those people that asked them. This topic elicited probably the most questions this morning. Let me speak to a couple of things that were raised, though, in the questions. First, people want to know about whether we can forward to them copies of the papers, the PowerPoints, and the actual presentations. So the papers are already up on our website, sblegal.ca. So if you go there this morning or this afternoon, you can download the papers. The presentations will be up on our website. So we did record this morning's presentations, and they will be on our website for those that want to see them. The PowerPoints are not going to be available in any medium, but all of the lawyers' email addresses are on the website. And if you would like a copy of the PowerPoint, I would suggest you email the presenter or one of the presenters involved, and they can send you a copy of the slides. So I hope that answers your questions about whether we can provide you with some legacy copies of what happened this morning.